the nation builder, and Bill Aqua Mineral Water. In less than 48 hours, the nation's Supreme Court, that is in less than 24 hours actually, the nation's Supreme Court will determine the validity of the election that returned President Akufo-Addo as winner and ushered him into his second term. 2020 NDC presidential candidate John Mahama is in court seeking an annulment of the declaration of President Akufo-Addo as winner of the polls and wants the Apex Court to order a rerun between him and President Akufo-Addo. The case, which has traveled the past 2 months, is expected to be decided tomorrow when the court renders its judgment after all parties have put their cases before it. A lot has happened since the case was filed, and the calls for supporters of both the NDC and NPP to conduct themselves well after the verdict is also deepening. We'll get into those shortly, but here's Kwekwa Sante's report read to you on all that has happened since the petition was filed on 30th December 2020.
On the basis foregoing election results and by the power vested in me as the chairperson of the Electoral Commission of Ghana and the returning officer of the presidential election, it is my duty and honor to declare Nana Addo Dankwa Akufo-Addo as president-elect of the Republic of Ghana.
9 December 2020, Electoral Commission chairperson Jean Mensah officially declaring President Akufo-Addo as having been validly elected as president. This was immediately met with protests by the NDC, who challenged the EC's figures, insisting the results were flawed. NDC presidential candidate John Mahama, along with other party leaders, argued the EC's correction of its own figures buttressed their point.
The sacred verdict of the people must be respected. It must be protected. It has been my pledge throughout my time of service as a representative to the good people of Ghana to do exactly that. And that is why I stand before you tonight, unwilling to accept the fictionalized results of a flawed election.
On December 30, after several street protests, John Mahama filed a petition at the Supreme Court seeking an annulment of the 2020 election results and an order of the court directed at the EC to conduct another election between himself and President Akufo-Addo. But documents it submitted to the court were riddled with errors. On January 14, 2021, the court sat for the first time to hear the petition and granted unanimously the request to amend the documents. The Supreme Court subsequently, however, dismissed a request for interrogatories to be served on the Electoral Commission. John Mahama was seeking to get the EC chairperson to answer 12 questions, which, in his opinion, would have aided the speedy resolution of the trial.
In the case of the interrogatories, if leave were granted and those answers were available, we would expect that the answers to those interrogatories would be available to put in evidence, which will then limit the scope of controversy.
Then came the time to call witnesses. Although John Mahama stated in his petition that he was calling 5, his lawyers called only 3 witnesses to the dock: John Singisiedu Nketia, Dr. Michael Pesa-White, and later Rojo Metal-Nunu.
My Lord, you claim my agents did not sign, which means that it's part of our case that the figures are in contention. But in the presidential elections, regions are not won.
I can say and maintain that it is on the basis of her instruction that we exited the place.
And even whilst there, you were offered tea and biscuits, not so?
I was offered tea. I wasn't offered any biscuits.
The court also rejected an attempt by lawyers for John Mahama to inspect some 6 original documents at the Electoral Commission.
In the instant case, the applicant has not raised any issue that he has no copies of the documents of the subject of this application. Of the fact that the proceedings so far shows the petitioner has copies of all the documents, the subject of this application. We are of the opinion that no proper case has been made before us to warrant the exercise of our discretion in favor of the applicant.
When lawyers for the petitioner closed their case, it was expected that the EC and President Akufo-Addo would open their cases and call their witnesses. But to the surprise of many, including the justices, the respondents opted not to call any witnesses.
We do not intend to call any witness. And my Lord, let me complete.
Order.
We do not intend to call any witness because in our view, they have not satisfied the burden of proof.
Lawyers for John Mahama proceeded to make a case to the court to compel Jean Mensah to testify. But the court rejected their plea, saying it cannot compel the EC chairperson to testify against her will. This ruling was appealed, but the court unanimously rejected the review application, insisting it had no powers to force witnesses to testify. The petitioner subsequently applied to the court to reopen his case and issue a subpoena to the EC chairperson to testify as a hostile witness. But that also failed. Subsequently, a review application against this ruling was filed in court, only to be dismissed by an enhanced 9-member panel. Of course, one cannot forget when the spokesperson for the petitioner's legal team, Dr. Dominic Ayine, was hauled before the court for making comments suggesting the panel had predetermined the case.
Lord Chief Justice, I did say those words. My attention was drawn to the fact that I might have crossed the line by Mr. Frank Davis, and Your Lordship, on the advice and consultation with my counsel, I have written to the court rendering an unqualified apology. I delivered that letter this morning to the Registrar of the Supreme Court to bring it to Your Lordship's attention.
All the parties in this litigation have filed their written closing addresses, and the court will render its judgment on the petition on Thursday, March 4. It's left to be seen if the 7-member panel of the court will affirm the victory of President Akufo-Addo or will order a rerun, as hoped for by John Mahama.
As Aqua indicated in the Kuglex case, heeding the promptings of conscience, as he put it, heeding fidelity to the judicial oath, he found it appropriate to reverse a decision of the ordinary bench. May each of your lordships decide in accordance with your conscience and your judicial oath. Ultimately, and even more profoundly, it is for the chairperson of the first respondent to come forward to testify as she indicated on oath she would do. I conclude with prophetic words that were spoken centuries ago. For they sow the wind, and they shall reap the whirlwind. These are the words of the prophet Hosea, to be found in Hosea chapter 8, verse 7. He that has an ear, let him hear.
A recap of the journey thus far. My colleague Kwekwa Sante joins me in studio with copies of the closing written addresses of all the various parties in this particular election 2020 petition. Kwekwa, let's start with the petitioner. What does it say in its closing address?
Right, so the petitioner continues to contend that per the figures that are available to them, and actually per the declarations made by the Electoral Commissioner, no candidate made 50% plus one of the vote. And so the court must, based on this, declare a rerun. And so you look at paragraph 8 of the election petition closing address filed by the petitioner. It says that PW1, who in this instance is Mr. Johnson Exedunketia, testified in paragraphs 9 to 13 of his witness statements to the figures cited by Mrs. Jean Adukwe-Mensah in her declaration, based on which he further testified at paragraph 16 as follows. Accordingly, based on the figures that the chairperson of the first respondent, Mrs. Jean Adukwe-Mensah, announced as part of her declaration, she acted in flagrant violation of the 1992 Constitution. And so they continue to say that, you know, there's this argument about Techiman South votes, and even if it's added onto the votes of President Mahama, will he be declared president or not? And so they continue to make the case in the closing argument that currently the election results we have declared exclude that of the Techiman South constituency, with a voter population of 128,000. They say if they add that to Mr. Mahama's figures, he will get 6,342,907, which yields him 46.768%. And if you deduct that total from the vote, and then the first respondent in this instance, Mr. Akufo-Addo, second respondent actually, will get 49.625%. And so they continue to make this case in this closing address that per all these documents and per these data that is available, the Electoral Commission should order a rerun.
You take us now to the respondents. Are they confident the court will affirm their case? We'll start with the first respondent.
Right. So the respondents, the first and second respondents, seem to go in unison to say that for them, they do not even believe that the petitioner has discharged his burden of proof to say that there's no prima facie evidence to suggest that this is an election petition, strictly speaking, and so that an election petition must challenge the outcome of the election. And they say that this petition is just coming out to challenge the mistakes which have already been corrected by the Electoral Commission. They say, for instance, in paragraph 4, that the purported declaration made on 9th December 2020 by Mrs. Jinadukwe Mensah, chairperson of the first respondent and the returning officer for the presidential election held on 7th December 2020, did not violate Article 63.3 of the 1990 Constitution and is therefore unconstitutional law, null and void and of no effect. And this is they quoting some paragraphs from the petitioner's petition that he brought to court. We must be very mindful of the fact that the court has set out some issues to deal with. The 5 issues, one says that did any of the candidates in the election, and this is me quoting, not verbatim what the court said, did any of the candidates in the election get 50% plus one of the votes? And so that is one of the cardinal principles. And at the beginning of the trial, the first and second respondent moved to throw away the petition on the basis that the petition does not come properly so-called. And so the court should throw that away. And we know that the court decision was that they were going to put that as part of the judgment as the final case. And so these first and second respondents dwelled much of their case on whether or not the proper petition, so-called, was one that the John Mahama petition filed.
So these are portions of the closing addresses, the written closing addresses by the petitioner, the first and second respondents, as my colleague Kweku Asante walks us through. But let's bring in lawyer Martin Pebu. We're grateful for your time here on Top Story tonight. You, I'm sure, like others, are very expectant of the court tomorrow as they prepare to deliver their judgment. What really will you say are your expectations?
Oh, number one, just as the Supreme Court did the last time, I'm expecting that they would make some suggestions as to how to improve our electoral system. Because, we've said a time without number that the mistake Mrs. Jim Mensah made in announcing the results is not the first. Indeed, Dr. Afarijan made a similar error in 2012. If you read the Supreme Court judgment, which is over 500 pages, you'll find it in there clearly. So to the extent that the same mistake has been repeated a second time, resulting in a petition to the Supreme Court, I think that hopefully the court would come up with suggestions as to avert such an error in future. That's the primary thing I'm looking forward to. And then something we all take for granted, but we shouldn't. The fact that we've come to the end of the case itself without bloodshed and all those things that years ago would have been expected from an African country is a big achievement in itself. Okay? Yes, that tells you that we are really making great strides in our democracy. So for me, that is one big intangible that I'm extremely happy about. That, look, even you see that not many businesses have not come to a standstill like what happened in 2012. You heard businesses saying that, a lot of investors, we are waiting for the results of the election petition. There's so much uncertainty and all that. This time, that. So these are very important milestones that we have chalked, and we should be proud of ourselves. That's it. Who wins or who loses, it's not much.
Well, we'll talk about the conduct, but there was a lot of talk about the case being resolved in 42 days. We know we have gone past that timeline. What do you say should be the consideration then going forward?
Yeah, so we fortunately, even before this petition was mounted, as far back as 2001, there's a Supreme Court decision called Republic versus High Court, ex-party, EPP, where they had dealt partly with this timelines issue. So the import is this. look, when you set timelines and you don't meet them, that alone will not invalidate the trial. Even apart from the expertise ECC I mentioned, there's also the other, the CI 47, where we have the timelines and the court can extend. So practically, this is what has happened. So for now, to the extent that at least it's not gone far beyond the 42 days, this should not generate much discussion. We have cases that the court may refer to some of those cases, but really it's not an important point. We've done well. It's not far beyond 42. Today, the 4th, tomorrow will be 4th. The case was started on the 30th, right? 30th December.
Exactly.
Yeah, because if you add, we've not gone too much beyond 42, so it's fine.
But that's what we're hoping to work within. But with this particular case, during the entire proceedings, for instance, we've seen a lot of challenge to the number of rulings that was put out by the judges or the justices of the Supreme Court. Is there room for a review of the court's ruling tomorrow, and how will that be done?
Oh, definitely. There is room for it. That is actually let's say...
I cannot hear what the other person is saying.
Yes. Being the final decision, rules allow for a review. The rules allow for a review. But maybe not to steal anything from Mr. Mahama, I'm hoping that just as the president did in 2013, you remember when President Akufo-Addo, the verdict was announced, he said he disagreed with the court, but he would not seek a review. I think Mr. Mahama's lawyers have done quite a yeoman's job, so I'm not expecting a review, if you ask me a personal opinion. But in the law, they have a right to.
Mr. Martin Pebo, we are grateful, and of course, we'll get to interact after that decision of the court is put out. The Ghana Bar Association says lawyers will be on hand to offer free advice and then also, education to the public on this matter. But let's bring in, representatives of the petitioner and the second respondents in this matter. There's been a lot of talk for peace after the declaration of the judgment by the Supreme Court tomorrow. We've heard from the Peace Council and other CSOs on this particular issue. But let's bring in Mr. Sami Jemfi. He's a member of the legal team and a spokesperson for the petitioner. We're grateful for your time here on Top Stories. So let's talk about preparedness. We've just read portions of your closing addresses and all. But from where you stand as the NDC and then, of course, the petitioner, what are your expectations ahead of tomorrow?
We are expecting justice to be upheld. We are expecting the truth to be upheld. But whether or not that is done by the Supreme Court, we believe that we have demonstrated to all objective minds who have followed this case that indeed candidate Akufo-Addo did not win the 2020 presidential elections. I think that has become manifestly clear to all objective minds who have followed the Supreme Court, the election petitions, proceedings in the Supreme Court keenly. And so to that extent, we are satisfied. We will be in court tomorrow at 9:30 a.m. and see what the court thinks about the issues. But let me repeat that for us, whichever way the verdict goes, we are very clear in our minds that the people of this country have gotten to know the truth. And that truth is that candidate Akufo-Addo was not validly elected as the president of Ghana in the 2020 presidential elections.
Well, the concern is, at least we've heard your expectations, and the concern is about the kind of talk that you're having with your supporters in terms of their expectations or managing their expectations ahead of the judgment tomorrow, such that we do not see any form of lawlessness. At least the Peace Council, for instance, have had cause to raise it to both the NPP and the NDC. So let's talk about what exactly
we are not a lawless party. John Mahama is not a lawless person. I think over the years, the NDC and our leader have shown that we have this country at heart. We are consummate Democrats, and we believe in the rule of law. And so And in fact, that is the reason why we resorted to this election petition when, after the declaration of the results, and we realized that what had been declared was not the true verdict of the people. We didn't take the laws into our hands. We have not done that before, and we will not do that tomorrow or the days after. And so, we are calm. We will be in court. We will hear the decision of the court. Sure, the full judgment will be ready at some point. Our lawyers will take their time and go through. We will make our position on the judgment known. If we are in favor of the decision, we will say so. If we think the decision is faulty, we will point that out courageously without any fear of contradiction. We will do so. And if there are any other rights that we can exercise in challenging the decision, should it not be favorable and should it be necessary for us to do so, we will do so in accordance with the laws of this country. Be rest assured that the NDC, its leaders, its members will not do anything to undermine the peace and stability of this country. Ghana is the only country we have, and we must always ensure that we use our systems and our laws to resolve whatever differences or disagreements we have with the system or decisions by our courts and state institutions. And that is absolutely what we will do.
That's good to hear. But Mr. Jemfi, we'll be hearing from the Supreme Court Justice, Yoni Kulendi, earlier today, asking the public to accept the verdict. They can criticize but not insult. But there is, a letter that your party wrote to the Electoral Commission, making a lot of rounds today, a lot of talk about it. What exactly is this? Is this the first time the party is electing to do this?
Yes, I think I don't even know why people are making a fuss out of this letter. But for the attachment that has been mischievously, circulated on social media to achieve a certain effect, I don't think that this is any issue that we should even be talking about. Because
so for those who don't know which letter we are talking about, Mr.
Regulation.
Sami Jemfi, for those who are not aware of the letter that I'm talking about, it's a letter that your party is demanding a refund. You've written to the Electoral Commission demanding a refund of your parliamentary and presidential filing fees for the 2020 general elections.
That has been the practice since 1992. The current public election regulations that we are operating under, CI 127, stipulates at Regulation 46.1 and 46.3 that every political party or every candidate has to make a certain deposit, upon filing to contest as member of parliament or president. Now, if they attain more than 25%. If the presidential candidates get more than 25% of the valid votes, the law says he should apply after the election for a refund. If the parliamentary candidate gets more than 12.5% of the valid votes, the law says he or she should apply for a refund of the deposit. The MPP has done it. All political parties who qualify for refunds have applied for refunds. It's been done over the years, and there is nothing untoward about it. What we have seen is that the EC, in response or in acting on this letter, actually prepared a document. And in that document, under the table provided there, they have stated presidential NDC percentage obtained 47.396. And that document, which is coming from the EC, not the NDC, and which has actually been signed by Dr. Shribu Okweku, has been released on social media and is being circulated with a letter our General Secretary wrote to create the impression that the NDC itself says that it got 47.396%. And so if they have accepted that is what they got, and they are asking for refunds on the basis of that, then why are they disturbing us in court? We want to put it on record that document, which has been attached to our General Secretary's letter and is being circulated on social media, is not coming from the NDC. It is the EC's document.
Okay, so then whilst you are applying for that, which you say is backed by law, you're applying for a refund, which you say is backed by law, you are also required to present an audited report of your accounts to the EC. Has that been done?
I believe it has been done. I have not. I believe it's been done because so far the correspondences I've seen shows that it's been done. I've not seen the EC raise any issue about that at all.
Okay, we'll leave it here. We wish you all the best. Mr. Sami Jemfi is a member of the legal team of the petitioner, also the communications officer of the NDC. We can now hear from Justice Yoni Kulendi asking the general public ahead of the delivery of that judgment by the Supreme Court tomorrow to accept the results.
And God willing, tomorrow the court will speak. When judges speak, that's the end of our role. It's not our place to get into studios, into debates, into commentaries, and to explain. That responsibility falls to you as the anchors who take information out. So if you inform, you can also misinform. Because at the end of the day, the Ghanaian people own the process. And it's important that they understand what went on, and that when the judges speak, irrespective of our preferences, our likes and dislikes, by the rules of engagement, the referee blows the whistle and the lots fall where they fall.
Justice Yoni Kulendi there, ending tonight's edition of Top Story, brought to you by Vodafone. The future is exciting. Ready? Also, Gassem, the nation builder, and Bell Aqua Mineral Water. Newsnight starts now.